बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलामु अलैका या रसूलुल्लाह वसल्लम अलैका या हबीबल्लाह। प्योर व्यूअर्स, उम्मीद करता हूँ आप तमाम दोस्त सब खैरियत से होंगे। अल्लाह रब्बुल इज़्ज़त आप तमाम दोस्तों को इज़्ज़त के साथ सेहत वाली लंबी ज़िंदगी अता फरमाए। और मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि हर नई आने वाली वीडियो आप तक पहुँच सके और आप भी इससे फ़ायदा हासिल कर सकें और इल्म हासिल कर सकें। प्यारे व्यूअर्स, आज हम पढ़ेंगे सेक्शन 189। Section 189, power to direct copies of deposition and exhibits to be received in evidence whenever any such offence as is referred to in Section 188 is being inquired into or tried. The provincial government may, if it think fit, direct that copies of deposition made or exhibits produced before the political agent or a judicial officer in or for the territory in which such offence is alleged to have been committed shall be received as evidence by the courts holding such inquiry or trial. In any case in which such courts might issue a commission for taking evidence as to the matters to which such deposition or exhibits relate. B. Conditions requisite for initiation of proceedings. Section 190. Cognizance of offence by magistrate. Number 1. The magistrates of the first class or any other magistrate specially empowered by the provincial government on the recommendation of High Court may take cognizance of any offence upon receiving a complaint of facts which constitute such offence. B. Upon a report in writing of such facts made by any police officer. C. Upon information received from any person other than a police officer or upon his knowledge or suspicion that such offence has been committed, which is may try or sent to the court of session for trial. Number 2. A magistrate taking cognizance under subsection 1 of an offence terrible exclusively by a court of session shall, without according any evidence, send the case to the court of session for trial. Section 191. Transfer on application of accused. When a magistrate takes cognizance of an offence under subsection of 1 class C of the proceeding section, the accused shall, before any evidence is taken, be informed that he is entitled to have the case tried by another court, and if the accused or any of the accused, if there be more than one, objects to being tried by such magistrate, the case shall, instead of being tried by such magistrate, be sent to the session judge and for transfer to another magistrate. Section 192. Transfer of cases. A session judge may empower any judicial magistrate who has taken cognizance of any case to transfer such case for trial to any other judicial magistrate in his district, and such magistrate has disposed of the case accordingly. Section 193. Cognizance of offences by courts of session. Except as otherwise expressly provided by this code or by any other law for the time being in force, no court of session shall take cognizance of any offence as a court of original jurisdiction unless the case has been sent to it under section 190. Subsection 2. Number 2. Additional session judges and assistant sessions judges shall try such cases only as the provincial government by general or special order may direct them to try or as the session judges of the division by journal or special order made make over to them for trial. Section 194. Cognizance of offence by High Court. The High Court may take cognizance of any offence in manner hereinafter provided. Nothing herein contained shall be deemed to affect the provisions of any letter, patent, or order by which a High Court is constituted or continued, or any other provisions of this code. Section 195. Prosecution for contempt of law, authority of public servants, prosecution for certain offence against public justice, prosecution for certain offences relating to documents having given in evidence. No court shall take cognizance. A. If any offence punishable under section 172 to 188 of the Pakistan Penal Code, except on the complaint in writing of the public servant concerned or of some other public servant to whom he is subordinate. B. Of any offence punishable under any of the following sections of the same code, namely section 193, 94, 95, 96, 199, 200, alleged to have been committed in or in relation to any proceedings in any court except on the complaint in writing of such court or of some other court to which such court is subordinate, or C. Of any offence described in section 463 are punishable under section 471, section 475 or section 476 of the same code when such offence is alleged to have been committed by a party to any proceedings in any court in respect of a documents produced or given in evidence in such proceeding, except on the complaint in writing of such court or of some other court to which such court is subordinate. Number 2. In class B and C of the subsection 1, the term courts includes a civil, revenue, or criminal court, but does not include a registrar or sub-registrar under the Registration Act 1908. Number 3. For the purpose of this section, a court shall be deemed to be subordinate to the court to which appeals ordinarily lie from the appealable degrees or sentences of such former court, or in the case of a civil court from whose degree no appeal ordinarily lies to the principal court having ordinary original civil jurisdiction within the local limits of whose jurisdiction such civil court is situated, provided that a. Where appeal lie to more than one court, the appellate court of inferior jurisdiction shall be the court to which such court shall be deemed to be subordinate, and B. And where appeals lie to a civil and also to revenue court, such court shall be deemed to be subordinate to the civil or revenue court according to the nature of the case or proceedings in conducting with which the offence is alleged to have been committed. Number 4. The provisions of subsection 9 with reference to the offences named therein apply also to criminal conspiracies to commit such offences and to the abatement of such offence and attempts to commit them. Number 5. Where a complaint has been made under subsection 1, class A by a public servant, any authority to which such public servant is subordinate may order the withdrawal of the complaint, and if does so, it shall forward a copy of such order to the court, and upon receipt thereof by the court, no further proceedings shall be taken on the complaint. प्यारे व्यूवर्स, आखिर में मैं आप तमाम दोस्तों का शुक्रिया अदा करता हूँ जो मेरे चैनल पर नए हैं। उनसे गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। अल्लाह आपका हामी और नासिर हो। इंशाल्लाह कल तक के लिए मुझे इजाज़त दें। कल इंशाल्लाह नई वीडियो के साथ हाजिर हूँ। अल्लाह हाफिज़।